Special argument developed. Now, we're going to get into a very special argument. This argument has taken 1812 years to develop, and I want you to pay attention. This argument is a unique concept that has been honed like a razor to a very meticulous edge so that you can understand what's going on. Obviously, we have established that you have a constitutional right, and obviously, we have established that you are the beneficiary of the contract. We have established that the Constitution is a contract in writing enforceable in a court of law, and that you have a right to claim specific performance on the contract. We have established that it is supposed to be interpreted in your favor. So if you have an honest constitutional belief, they have to listen. Now let us take that to the next step. Can a state arbitrarily and erroneously convert your right into a privilege and issue a license and a fee for it? Murdoch v. Pennsylvania, 319 U.S. 105, 1943. Supreme Court trumps everything else. Murdoch is basically a religious test case. A religious group wanted to go out and preach among the public, as that is their right to evangelize. Pennsylvania wanted them to have a license to solicit. The group claimed their First Amendment right of life, liberty, and the pursuit of happiness, the right to worship and exercise their religion unencumbered. The points on the case that are established are a state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberty of press and religion, and inevitably tends to suppress the exercise thereof. That the ordinance is non. 15. Discriminatory, and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are in a preferred position, since the privilege in question is guaranteed by the federal Constitution, and exist independently of the state's authority. The inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert a secured liberty into a privilege and issue a license and a fee for it. Now a lot of people will come back to me and say, well, I am not a part of that religious group. It doesn't apply to me. You need to reach. Understand we're not talking about whether you are in the religious group or not. We're talking about here is are you an American and do you have? What they are talking about here is that religious group exercised their rights timely, that they had a right to worship and evangelize as they chose, and that the state came in and arbitrarily converted that right into a privilege and issued a license and a fee for it. That is totally unconstitutional. Now we took that case as a pioneering case, and we argue that case for all of your constitutional rights. All you need to do is keep in mind that 1. You are an American, and that you have constitutional rights. 2. You have to keep in mind, what right? Can you pull the right out of the Constitution? If you can pull the right out of the Constitution, and I will give you an example. How about the right to travel freely and unencumbered, pursuant to Shapiro v. Thompson, 394 U.S. 618, 1969? How about the right to keep and bear arms? Does the state have the right to require a license and fee for the exercise of the right? And if they do, can you ignore the license and fee? The premise of this case is clearly established. No state may convert a secured liberty into a privilege, issue a license and fee for it, and require you to have that. Otherwise, you committed a crime. Let us jump to the next case. Shuttlesworth v. City of Birmingham, 373 U.S. 262, 1963. This is another unique religious case. In this case, 6 ministers were accused of inciting to riot and otherwise create a disturbance. Disturb the peace. They had a sit-down. This case came down in 1962. The city said they needed to have a license to have a public gathering. It went to the Supreme Court, and the Supreme Court said, no, you don't have to have a license for the exercise of a First Amendment right to freely assemble. The gist of the case is that Negro ministers were convicted in the Alabama State Court of aiding and abetting in violation of criminal trespass ordinance in Birmingham, Alabama. The only 16. Evidence against them was to the effect that they had incited 10 Negro students to engage in a sit-in demonstration at a white lunch counter as a protest against racial segregation. The court held that, on the case of Peterson v. City of Greenville, 373 U.S. 244, 1963, that the convictions of those 10 students for criminal trespass were constitutionally invalid. Since those convictions had been set aside, it follows that these petitioners did not incite, aid, or albeit any crime, and therefore the convictions of these petitioners must be set aside. Now basically what they were claiming was their constitutional right to freely assemble. The city was claiming that they had to have a license to put on a demonstration, which they didn't have, and they were charging them with a criminal trespass for not having a valid license to freely assemble and/or protest. Now I want you to see the significance of this case in view of the case we just had. Murdoch v. Penn clearly established that no state could convert a secured liberty into a privilege and issue a license and a fee for it. Shuttlesworth v. Burm said that if the state does convert your right into a privilege and charge a license and a fee for it, you can ignore the license and fee and engage in the right with impunity. That means they can punish you. They have to let you go. It is very important that you understand first your Constitution is the supreme law of the land, and that you have that right, and that right shall not be infringed, and it is supposed to be enforced in favor of you, the clearly intended and expressly designated beneficiary. It is very important that you understand that no state may convert that right into a privilege and issue a license and fee for it, and if they do, Shuttlesworth says you can ignore the license and engage in the right with impunity. They can punish you. Now, the next case is very important, and it is important that you see the argument. U.S. v. Bishop, 412 U.S. 346, 1973. Basically what Bishop does is it sets a standard for what constitutes a criminal violation in terms of willful intent. Willfulness is one of the elements which is required to be proven. In any criminal element, you have to prove that one. You are the party, too, that you had a method or opportunity to do a thing, and 3, that you did so with a willful intent. Now, when we get to willful intent, willful is defined as an evil motive or intent to avoid a known duty or task under the law with immoral uncertainty. Obviously, you have decided that you have relied on the United States Constitution, and you have relied on the decisions of the Supreme. 17. Court, so could you have willfully done any deed or crime? Obviously not. So this case stipulates that you have a perfect defense for the element of willfulness. Since the burden on the prosecution is to prove that you did willfully and knowingly avoid a known duty or task under the law with immoral certainty, he cannot perform that task, because you obviously have your constitutional immunity to that. The previous case, Shuttlesworth says they couldn't even punish you. The case before that said you don't even need a license for the exercise of a right. And the case before that said your constitutional right is supreme over any state law. So if they pass a law in violation of your Constitution, the Constitution overwhelms the state law, so the law doesn't even exist in law. Now, since the prosecutor does not have a cause of action for which relief can be granted, Your Honor, would it please the court, counsel is specifically precluded from performing his major task. Therefore, Your Honor, would it please the court at this time, I would motion most graciously for dismissal with prejudice for failure to state a cause of action for which relief may be granted by this honorable court. And I kinda like to collect my costs and fees for having to defend this patently frivolous and spurious complaint. Sir, may it please the court. This argument is a killer argument. It is good for every single constitutional right you've got. All you have to do is fill in the blanks. What constitutional right? Prove you have the constitutional right. Tell them that the state does not have the right to convert that right into a privilege, and they can punish you if they do. And then claim that the prosecutor prove willfulness so you obviously didn't do any crime. And then flip around and demand for you dismissal, which is your right, and get your costs and fees for having to defend this frivolous case, may it please the court. And I promise you, you will be amazed at the results. These things have personally happened to me. I can relate the exact cases. That goes for practicing law without a license. Obviously, you have a right to work, the right to contract you labor as you see fit, not as some arbitrary and capricious bar association sees fit. If you don't want to belong to the union, that's your right. You are in a right-to-work state. The bottom line is this. They cannot compel you to have a license or pay a fee for the exercise of your right. And if they do, you can ignore the license and engage the right with impunity. That means they can punish you. And since you have a perfect defense for the element of willfulness, punish you. They have to dismiss, don't have a cause of action. Now this argument, I am telling you, has taken us over 18 years to develop in the courts and in law libraries over the years, compiling and arguing cases and using this argument. It's a killer. 18. Argument. Have they ever won against us on this argument, nor could they in the United States of America as long as the Constitution stands. Pay attention to this argument and start using it. We'll show you some of the techniques later. Now the word willfully has the same meaning, all right, in controlling the voluntary intentional violation of a known legal duty. And the distinction between the statute is found in the additional misconduct that is essential to the violation of the felony provision. If they can prove willfulness, they can prove nada.